Good afternoon and welcome to NCIA's Industry Essentials Educational Webinar Series, our premier digital educational platform featuring a variety of interactive programs to provide you timely, engaging, and essential education when and where your team needs it most. My name is Brian Gilbert, the Deputy Director of Events here at NCIA, and as always, I'm very excited to welcome you all to another edition of our Committee Insight Series programs, today being hosted by NCIA's Cannabis Manufacturing Committee. Now, let's get this show on the road. In today's program, members of NCIA's Cannabis Manufacturing Committee continue their multi-part future-proofing series of programs with a session entitled Future-Proofing Cannabis Manufacturing Processes from Sustainability to Acquisition Readiness, in which they will explore the current and future landscape surrounding sustainability and manufacturing in the cannabis space. Well, I know our panel is eager to dive into this discussion and our audience is interested in having their questions answered along the way. So let's not waste any more time. To kick things off, I'd like to welcome back a member of our panel to today's session, Emily Long, the Senior Project Manager at Byers Emission Analysis, to the virtual stage to kick things off by introducing our panel of environmental, sustainability, and data integrity experts. Welcome to NCIA's Industry Essentials Educational Webinars. Great to have you back today, Emily. You can activate your video feed along with the rest of the panel and take it away right from here.
Thank you, Brian. I'm happy to be here. Hope everybody can hear me okay. My name is Emily Long. I am the Senior Project Manager for Byers Scientific, Byers Emissions Analysis. And just a brief intro about myself. The firm that is Byers Scientific works to quantify plant emissions from cannabis and then engineer proper mitigation technologies according to that data. I will pass it along to Paul Coble to introduce himself.
Good afternoon, everyone. My name is Paul Coble. I'm a chemist by training, and then after undergraduate, I went to law school and practiced intellectual property law in Chicago for about a decade. In 2018, I founded Thalo Technologies to develop software and data products for the cannabis and hemp industries. I am currently the vice chair of the NCIA's Cannabis Manufacturing Committee and am adjunct faculty at Excelsior College for cannabis policy and risk management. John?
Hi, everyone. I'm John Howard. I'm an attorney and partner at the law firm of Quarles Brady. Quarles Brady is a full-service law firm that handles everything for businesses from corporate law to tax to real estate, employment, and everything in between. I lead our firm's Arizona business law practice, as well as M&A practice, and in particular, our cannabis practice. I've worked with national MSOs all the way through local dispensaries and quite a bit in between in M&A transactions and raising capital. So looking forward to talking with you today.
Thanks, John. Brian, I can just jump right in. I'm going to open us up with some kind of high-level discussions about environmental sustainability and sustainability overall for the cannabis manufacturing processes specifically. So as we know, as members of this industry, there is a pretty serious data vacuum, which we feel is certainly holding back advancements in sustainability. And some thoughts on this. The pioneering of a lot of these chemical processes that manufacturers are running are advancing quickly. However, there is not a lot of data being mined or excavated from these processors, and therefore it's difficult to make these processes more sustainable and more efficient with that lack of data. And reason being, there's a lot of fear associated with sharing of the processes and that information. Fear of negative regulatory pushback, for example, is a big one. A lot of times reasons for why processors do not want to share the types of processes that they're running to create their manufactured products. Another issue is, and I say misconceptions, IP concerns. But yes, a lot of them are misconceptions, and Paul will get into that a lot more when he speaks after me. And a lot of those misconceptions about IP and the, the legal frameworks around trying to protect your assets, it leads to ultimately, not wanting to share information, and therefore halts advancements in sustainable practices. So ultimately it works against the industry as a whole when there are these misconceptions of IP. So that low visibility really inhibits the standardization of these processes, which would help product and consumer safety. And as we've seen in the news, there are incidences of major players in the manufacturing world producing products that are, having to be recalled. And it's a major health, consumer safety issue. So this could be avoided with more sharing of information and better understanding of IP. Next slide, please. Cannabis science is outpacing regulations. Again, this is something that a lot of us who are in the industry understand. This market, part of the reason being the market was, only a few years ago illegal. So a lot of these processes were being developed, for lack of a better term, in the black market. So they have outpaced regulations, and in a scramble to kind of catch up, the regulators are, prescribing a very prescriptive regulatory framework based on not a lot of data. It's based on, fear a lot of times of trying to stay ahead of regulating this industry, and as far as the manufacturing processes. And this often leads to blocks for innovation, for more sustainable processes and strategies and operations. Regulators are trying to stay on top of regulations, and these mandates then are a little misguided and have unintended consequences. And yet another barrier to entry for the cannabis industry that is not based in science and data. It's based on a lot of times speculation. So if the regulators were able to focus more on standards of manufacturing processes, progress would be made, which is something that as a committee we believe. An example of the sustainable practices that could have been developed or could be developed, for example, would be recycling and reusing the resources that are generated by your processes. Examples of those would be intelligent use of exhaust recirculation optimized with right-sized odor mitigation solutions, ventilation minimization, demand control ventilation for providing makeup air, etc. Just being able to, recirculate your exhaust and airflow within your facility, coinciding with proper odor mitigation solutions and HVAC systems. All of this would have to, work together, but could be made much more efficient if done correctly. And so another point here is the data from operating facilities using these different strategies is ultimately the best guide to determine how to save energy and reduce waste coming from these processing facilities. Thanks, Brian. Now I'm going to talk about a little bit about cannabis extraction and how that relates to air quality and odor issues, which go hand in hand as far as environmental and community impacts. Many of you may know this. Volatile organic compounds are emissions coming typically from the chemical processes being run, a lot of times attributed to the solvents that are being used in extraction. And then the BVOCs, which are biogenic volatile organic compounds, those are the emissions coming from the plants themselves. A lot of times there's a misconception that odor and emissions are only a problem for cultivators. That is not the case. A lot of major manufacturing facilities, especially as they scale to pretty commercial levels, there are significant emissions coming from those facilities as well that are both potentially impactful negatively for the workers as well as the environment and communities outside. Best practices for emission control would be, obviously, and many of us know, for extraction, it would be having a closed loop system, maintaining proper solvent storage and transferring, performing extraction equipment inspections to make sure that there are no systems leaking that would produce more VOC emissions from your processes. And lastly, in making sure to have a maintained inventory and handling of solvents and making sure that that's part of your facility's SOPs. That's a big one as well. I know a lot of enforcement agencies that I'm familiar with will calculate your total emissions for the year based on, if you don't have all of that information tracked as far as your solvent use and handling, and how much is being, worked through your closed loop system, and showing that you have all of those systems up to date as far as no leaks. If you don't have that information, they're going to assume the worst case, and they're going to just look at, okay, you use all of this solvent throughout the year. Well, we're going to base your VOC emissions into the atmosphere based on that. And that's not going to look good for you. So it is very important to carefully track that inventory and store properly of those solvents. Lastly, the best management practice known out there right now for controlling cannabis terpenes, which again are those BVOCs, as well as the other VOCs from the solvents and the processes, will be carbon filtration. And it is important to install properly engineered molecular filtration systems, aka carbon scrubbers, that are sized appropriately for a facility's emission load and do not exceed the maximum cubic feet per minute rating for air circulation through the filter. That helps to reduce unnecessary use of energy by being able to install that properly engineered scrubber system that is sized appropriately for your facility, will reduce energy use as well as wasted and spent carbon, and will ultimately control the emissions escaping from your facility, which could negatively impact the environment and the community. Many people may not realize that carbon scrubbing, although it is mostly known in our heads as odor control, it actually does coincide with VOC capture, which is can negatively impact the environment outside. So you're doing both when you are right sizing that equipment for your facility. In this slide, I'll kind of continue on here a little bit. To prevent VOC and odor breakthrough, it's important to inspect and conduct regular maintenance of your HVAC system and odor control systems to make sure that there is no breakthrough. Breakthrough is what a lot of times the main issue behind odor complaints coming from local communities, and it's preventative or it's preventable is the word there. And two different ways that can be done is a butane life test of your carbon filtration of your scrubber. You can actually run that test. It's not very time consuming or expensive, actually, so it's not resource intensive to run that butane life test. It's a standardized test, and it will actually show you the life of your carbon that's left, which allows you to maximize your filter life and maintain proper odor control performance at the same time. Which allows you to build that into your facility management system to make sure that you don't have breakthrough from a mathematical standpoint. And then next here is air sampling to detect and measure VOC and odor levels at your facility. This is another way to prevent breakthrough, is to understand what is actually going on in the air in your processing facility when you're running these processes, and measure those VOC levels and odor levels at that specific time. And that way you can install proper mitigation technologies according to that information, according to what comes back from those sampling results. This would be the emission load data that can be used as a baseline metric to validate the efficacy of control technologies and protect worker and environmental health. This data also is important for proving and supporting compliance with local regulations when it comes to a lot of times odor control is what they're really targeting, and emissions control is coming down the pipeline. I know in Colorado for MIPS, the manufacturing facilities, specifically related to VOC emissions from your facility, the regulations are tightening and being enforced coming in the next couple months. So proper VOC and cannabis odor control for manufacturing processes does help reduce community odor complaints, which I have touched on, and improve neighborhood relations. A lot of times in the news, we see some negative press, if you will, from these major brands that we love so much. And that's not good to have that negative press. And, some of that can be equated to the stigma on cannabis, but a lot of times it, either way, regardless of it, if it's more subjective or more objective of a complaint, it is not good for your business. So to truly prevent those problems, you really want to look at your emissions control pretty carefully. And also improve public and environmental health by reducing local ozone concentrations, which again, when you have proper emissions control installed in your facility, you're able to reduce those VOCs and BVOCs that are potentially creating low-level ozone, specifically in urban areas. I know in Denver, Colorado, we do a lot of our manufacturing facilities are in industrial urban areas, and we have VOC limited. So the low-level ozone concentrations can be pretty drastically impacted if those emissions are not controlled. So that's just a couple of kind of overall thoughts on sustainability, odor and air quality in regards to extraction processes. And I will now pass it on to Paul to speak to some legal issues.
Thank you very much, Emily, and welcome everyone. So today I wanted to talk about how cannabis manufacturers can use intellectual property to kind of prepare their businesses for the next stage and future-proof their manufacturing businesses as competition opens up among many other states and eventually, potentially international competition. So let's go to the next slide. Before I dug too much into it, I wanted to, as Emily alluded, clear up some misconceptions about intellectual property, because I find that not everyone understands the various types of intellectual property and how they interact. So my analogy here is putting a cloud in a bottle, and I think it's actually a pretty good analogy here. So ideas are similar to clouds in this analogy, where they all have a unique shape and unique size and unique appearance. They might have incredible power in storm clouds. They might be ephemeral, but they all share the characteristic that they are difficult to convey to other people. They're difficult to put conveyance around and transfer to someone else, or to protect others from taking it. So intellectual property is the legal framework that we put around ideas simply to give them structure, to make them fungible commodities that can be bought, sold, licensed, and protected. And so the intellectual property is the structure that we put around these ideas simply to give them structure. So with that in mind, IP is a tool. It's not inherently good. It's not inherently evil. It is a tool that is intended to solidify the intangible. And it's what we do with that intellectual property that can cause problems in an industry, or it can advance an industry very rapidly. IP was originally intended to increase transparency into technology and scientific advancements. It's in our Constitution, Article 1, Section 8, Clause 8, to promote the advancement of science and technology, science and useful arts. Congress has the power to create what would become our patent and copyright systems. The idea is that there's a social contract between inventors to make and disclose their inventions publicly. The trade-off for that is that we will give them a limited exclusive right to sell that technology. So in exchange for telling us how you did it, we'll give you the exclusive right to use it for a limited period of time. So IP can be used to facilitate information sharing by providing bounds around the ideas and a structure that has legal significance. We can feel confident in sharing those clouds with other people, those ideas that were previously too intangible or too difficult to share without some sort of legal protections. This all kind of leads to the evergreen question of what does enlightened IP strategy look like in the cannabis industry? IP strategy varies from industry to industry, and it changes significantly over time. Anyone who's familiar with IP in Silicon Valley has seen it shift dramatically over the past just 20 years. So in the cannabis industry, we have a unique position to determine how we want to approach IP in an enlightened manner that advances the industry instead of holding it back. So with that, I want to kind of go through the various types of intellectual property and how they relate to cannabis manufacturing businesses. I've lumped these into three different categories. The first is patents and copyrights. These are IP that is intended to promote advancements in science and technology. And so this is the social contract I was referring to, where we give exclusive rights in exchange for public disclosure for how you did it, what your invention is, depositing in that information with the US Patent and Copyright and Trademark Office so that everyone has access to it. Trademarks and trade dress are a little bit of a different beast, and these include subcategories like certification marks and service marks and things like that. These are intended to protect consumers, and they are intended to ensure that consumers always have a reliable way to identify the origin of any particular good or service. So, think brands and, slogans and logos. Those were developed to inform consumers as to where products came from and provide some sort of chain of accountability for consistency and safety and things like that. And the final bucket is trade secrets, which is kind of a catch-all provision for things that we recognize have commercial value, but don't fall neatly within the other two buckets. And so we provide a somewhat more limited framework to protect trade secrets. I'm not going to talk a whole lot about trade secrets in this presentation, mostly because they don't really fit as neatly with future-proofing your business, other than to say that that NDAs, non-disclosure agreements, I think are very prevalent in the cannabis industry and a little bit too prevalent. And I think that if individuals and companies had a better sense of what their true intellectual property was, what was valuable to their companies, and had an idea of what the bounds of those properties were, we'd see fewer NDAs in the industry, and I think that would be a benefit to us all. So to dig into patents a little bit first, these are probably the most commonly known type of intellectual property and probably one of the most commonly misunderstood. The US is a first to file rule like most of the world now, which means that it's a race to the patent office. Whoever gets to the patent office first to file your patent application will generally have priority in receiving that patent. There is importantly a statutory bar that if anyone uses publicly or publicly discloses or publicly offers for sale anywhere in the world, even one day prior to your filing the invention, then you are barred from getting a patent. Everyone is barred other than, with limited exceptions, the inventor who made that public disclosure, use, or offer for sale. So it's important to understand when you're looking at patentable inventions, understand quickly what you have, what you're inventing, and what you intend to do with it, so that you don't, forfeit any rights to patents forever. That can also be used offensively in certain situations to file information that you don't want other people to have the ability to get patents on. So it can be used both offensively and defensively, but that statutory bar is very important in the world of patents to keep in mind. A couple of the main requirements for patenting, and there are many others, but the idea has to be novel, which means it's new, has not been written or disclosed by anyone anywhere prior. It has to be non-obvious, which means it can't just be an incremental improvement. Generally, this is a change in colors or swapping out the materials with no real effect on the overall invention. And the third key or big requirement for patents is that they have to be useful. And generally, this is a fairly low bar for most inventions. But when we're talking about pharmaceuticals or therapies, it is not a non-existent bar. And the utility requirement is something that it needs to be taken into account, especially when we're talking about pharmaceutical or therapeutic or formulation inventions. I'll get to those in just a minute. If you do satisfy all of these requirements, you are granted a patent which comes with very broad rights. They're exclusive rights to make, use, sell, offer for sale, or import into the United States for a period of time. And we'll talk about that on the next slide here. Period of time varies depending on the patent we're talking about here. Utility patents are the most common. Those are 20-year term from the day you file. That usually shakes out to about 17 years from the date of issuance. They can cost anywhere from $5,000 on the low end to $15,000 up to $25,000 per patent through examination and issuance, if we're talking something like genetics. And that it can take 2 to 3 years to work its way through the examination process. It's a fairly rigorous process and involves a lot of back and forth with the patent office. Utility patents can cover a number of different types of inventions, machines or apparatuses. So think, extraction equipment, lab equipment, handheld vaporizers would all fall into kind of the machine or apparatus categories. Really, anything that you can touch generally will fall into a utility patent category. Methods, which includes processes, so specific process of producing a manufactured product or a process of producing a new manufactured product that happens to be new, can be protected with a method patent. Methods are also used to protect therapies. So for example, treating epilepsy using a solution of cannabidiol is a patentable method. Other methods and processes are certainly working their way through the patent office right now. There's a ton of them out there. I have a lot of thoughts on that and how that's going to shake out. It's a little bit beyond the scope of this, but do know that those all kind of fall into the utility patent category. Final category of utility patents are compositions of matter, and these include anything from formulations or solutions to genetics. You can protect using the composition of matter category the specific genetic material, and that's usually done by depositing seeds with the patent office. But that only protects then people who are making or growing plants with that exact same genetic material, meaning from those seeds that generally have to be obtained from the patentee. So there's some limits there. On the other hand, plant patents can protect, so going back, the genetic utility patents can only then protect seeds, which is sexual reproduction of the plants. Plant patents, on the other hand, protect asexual reproduction. So if you can create a stable and distinct plant varietal, you can obtain a plant patent that lasts 20 years from the date of filing and would cover all asexual cloning of that plant. Again, it's limited to the actual clones of that plant, so there's some limitations to the patent itself, but it is relatively simple to obtain. Design patents are kind of the third broad category. Design patents protect anything ornamental, anything that is non-functional and only visual, which means it can protect logos, it can protect packaging if it is non-functional, and it can even protect product designs, though there is somewhat of an uphill climb to prove that your design is ornamental, purely ornamental and not functional in nature. And then with utility patents, there's also the option to file a provisional patent, which essentially extends your term up to a year, gives you 1 year to decide whether or not you want to pursue full patent protection before kind of shelling out that large commitment of resources to a full utility patent. Copyrights are the next big section of IP, and they are somewhat broader than I think most people realize. Originally, they were intended to protect simply writings and expressive writings, but that has kind of expanded to now protect really any sort of non-functional expression. And it can be debated whether these are functional or not, and that's a whole nother webinar. But copyright can now be used to protect writings, photographs, compositions, recordings or audio recordings, sculptures, and that can include things like soft sculptures, which might be like types of clothing. And then it has been expanded in recent years to include things like source code, algorithms, and compilations of data. And these last ones, I think, are some of the most interesting categories and have the biggest implications for the future of intellectual property, because recent case law has said that if you put subjective choices into your algorithms, into your compilations of data, you make subjective determinations when you are creating those things, the outputs of those algorithms, the compilation of the data can be a copyright protectable work. It's a thin copyright and has very limited protections, but it's something that people should certainly be aware of, that things like benchmarks and projected yields might be copyright protectable works that are not free to copy and take. And if you do the appropriate legwork up front and have those types of works in your business, you might be able to claim those as intellectual property. Broadly speaking, for copyrights, they must be original, creative, and fixed in a tangible medium. The first two bars are pretty low bars, actually. Originality in this context simply means that you didn't copy it from someone else. It doesn't mean that no one else has created the exact same thing. Two people can create identical works independently and both receive copyrights in their work. Creates a ton of problems later, but it's theoretically possible. Copyrights also must be creative. And again, very low bar. We don't want the Copyright Office determining what is sufficiently creative or not to receive a copyright. So we basically just say, if you exercise some sort of subjective creative determinations in creating this work, it could be something like a film or a lens choice in a photograph, that is sufficient creativity to obtain a copyright. Similarly, if you are creating a list of the best Chinese restaurants in Boston, actual case, you necessarily are making some subjective determinations as to what you think means is the best. That list can then be copyright protected. Finally, fixed and intangible media. This is simply to distinguish between, if you play a song out loud and no one records it or writes it down, it doesn't have a copyright. If you play that same song and record it, it gets a copyright. Those copyrights fix automatically as soon as you fix them within the tangible medium, as soon as you record them or write them down. But it's important to actually register copyrights if you want to obtain enhanced damages, which actually provides some real teeth into the copyright, or enforce it in court. The last broad category I want to talk about are trademarks and trade dress. As I mentioned before, these are a category that are intended to protect consumers from being confused in the marketplace as to where their goods came from. It's so that you don't go to a McDonald's on one side of the country and think that it is affiliated with or mistakenly think that it is affiliated with McDonald's on the other side of the country. Consumers should have the ability to rely on those indicators of source to understand where their goods and services come from. So these are very broad and can include the traditional things like brand names, company names, model names, slogans, packaging, but they also include other types of indicators of source, like presentation. Apple stores have a unique look and feel. Other dispensaries certainly have unique looks and feel that dispensary owners may wish to kind of solidify into protectable trade dress. Actually, the seminal case of trade dress was about two competing taco cases, two taco stands, 2 Pesos versus Taco Cabana. They had similar colors, similar look and feel, similar layout, and the Supreme Court said, yeah, that is sufficient that consumers might think that they are related. So there may be some trade dress cases eventually working their way through the courts relating to things like the look and feel of dispensaries or packaging around cannabis products. Colors and sounds are also fair game for trademarks and trade dress. They're more difficult to obtain. They generally take about 5 years of consistent use, and you have to often lay some significant groundwork with advertising that specifically mentions the colors. You know, what can brown do for you from UPS? Look for the salt in the yellow packaging from Morton Salt. These are intended to kind of lay the groundwork for those color trade dresses and trademark registrations. Currently, federal registration is not available for federally legal products. Many people probably know this. So you cannot get a federal trademark registration on goods and services that are federally illegal, i.e. cannabis. However, you can get federal registrations on the same trademark being used on legal goods and services that are ancillary to your cannabis business. And those might be within the zone of expansion, such that you can start to acquire federal trademark rights in cannabis products right now that will be enforceable later with the appropriate groundwork now. And we're actually already seeing that in a few cases. There's one brought by Edible Arrangements that is claiming to have a trademark on a CBD line of edibles, and they are claiming that that CBD line of edibles is within the zone of expansion into a high THC line of edibles. So we're already seeing those types of issues play out. It's certainly something to be thoughtful of right now. Trademarks and trade dress infringement. This is a super complicated area. Most most IP attorneys also don't even understand that. It is highly factually dependent. So if you are at all concerned about these issues, just talk to an attorney about a trademark attorney about this, because it is really dependent on the particular facts of your case. It's not an ownership of the word and phrase. I see this all the time in media and popular culture. Apple doesn't own the word apple. You know, they own it for the goods and services that they are into, and other uses, as I'll get into in a second, for famous marks. But generally speaking, you are awarded trademark rights only for the area in which you are actually using those trademarks. And we use a variety of factors to figure out whether someone else is infringing upon that. But the key takeaway, I think, from this list here is that only 2 of those factors relate to the marks themselves. You can have identical marks, and only 2 of those factors are at all influenced. The rest of those factors relate to how the goods and services are presented to consumers in the marketplace. And so it is about a holistic view of how consumers are going to approach and view these trademarks, and whether they're likely to be confused by it. One major exception, and I love to bring this up because I see it all the time. It is very prevalent in the black and gray markets, but it is all too prevalent as well in the legal markets. And that is, there is one exception to the framework I talked about before, which is for famous marks. Famous trademarks that are well known very, very broadly are given rights beyond just the goods and services on which they are used. These are called dilution rights, and basically they prevent you from trading off of a famous mark in a new industry. This is really common in the cannabis industry, and it really needs to stop, because you're going to get sued and they're going to be right. You know, it happens a lot. We've seen it in a bunch of strains up till now. Gorilla Glue, Girl Scout cookies, just as some examples. I think Skittles has just brought a suit. I don't know all the details of that, so I'm not going to step too deeply into it. But you know, avoid famous marks. It's just not worth it. And my question to clients who want to use a mark like this is always, well, what's your purpose in using that mark? And if it has anything to do with, well, it'll remind people of stop, pick a different mark. So with that caution on famous marks, I'll go to what I think is my last slide, and just some tips and tricks on trademarks and trade dress. it's worth filing registrations now. File registrations on the legal goods that are within the zone of expansion of non-registerable products. Talk to a trademark attorney and see what is available for you. Look at state registrations. California, Washington, a number of the legal states have state trademark registrations available for goods and services that are legal within their state. But also it's worth talking to trademark attorneys to develop strong branding. Conduct pre-clearance searches so that you're not stepping on other trademarks out there or encroaching on others' rights that might have a problem with that in the future. Develop brand standards that are going to increase the strength of your trademarks and trade dress down the line, and vigilantly watch out for others who are using it. Doesn't mean you have to file suit whenever you see someone who is encroaching on your trademark, but sometimes it's worth a conversation to talk to people and make sure that your brands are distinct and that your intellectual property is being respected on both sides of the aisle. So with those words, and I'm sure I'm well over my time, I'll turn it over to John to talk about some of the other ways that you can prepare your business for acquisition down the road.
Absolutely. Thanks, Paul. Well, looking at the various deals. So as I mentioned at the beginning, my firm has dealt with a wide range of cannabis related deals. We're a national law firm, so we do deals all across the country. We've represented everyone from small players who are growing a new business to some of the largest MSOs that you see reported in the papers and on the news streams on a daily basis. And from that perspective, it's really given us the opportunity to see what is important in preparing your business for a sale and really for any other kind of transaction. I'm probably going to focus this presentation on the idea of from the standpoint of a smaller business being prepared to be purchased by a larger entity, but a lot of this stuff goes either way, right? You could be a growing business that wants to acquire some licenses, acquire some new locations, expand your footprint into other markets. And this is really important, whether you're on the sell side or the buy side. If you're on the buy side, you want to make sure that your potential target is doing these things. And as a seller, you want to make sure you get ahead of some of these issues so that you will look attractive to potential buyers and that you're also compliant in running your business in the event you never do a deal. A lot of this is just good corporate governance, good operation of a business. I'll also say there's just a lot of different kind of deals, again, focusing on an acquisition transaction here, but we help companies raise money all the time. We help the acquisition of maybe just discrete assets, a license, a facility, real property, whatever it might be. But a lot of these broad principles play across the board. So if you are going to prepare for a deal at some point down the road, one of the things to think about, I want to walk through the deal process a little bit, and that'll give us a chance to dive into, okay, why is this important? Why do you care about keeping your IP up to date, as Paul mentioned, or paying attention to environmental matters, as Emily mentioned? So where do you even find a deal? A lot of times you have your industry contacts. And again, if you're maybe a smaller business, a lot of the big players are looking to just aggressively expand their footprint. And they have large amounts of capital that they need to deploy. And so industry mixers, things like that come about. A more formalized process, if you're interested, is you've come to a point, you want to sell, you think you've seen a particular price point that you may be able to, generate that return that you've been working for a number of years, and you go out and find an investment banker. And I work with a lot of investment bankers in the industry. Happy to help position anybody who's looking to get themselves ready for a deal. But that investment banker is basically like a broker. You think about a broker in just like the housing industry or any other industry. They know the buyers, they represent you as a seller, they take a percentage, but they really can add a lot of value from the perspective of taking your financials, taking your operations, packaging them in a very attractive manner, getting them out on the market, and bringing you potential buyers. So then, once you have found one through whatever method it is that has occurred, what you want to start doing is making sure that your house is in order. And that'll come in a lot of different ways. And I'll talk about that on the next slide from the due diligence standpoint. But you start looking at the transaction process. So you've worked with, let's just say you've gone the route of using a broker, you've found some potential buyers. You'll probably have a batch of them, and because you really want to find the right fit. I always tell this to all sellers, especially if you're going to have an ongoing investment in the business. You're still going to be operating in some way. Maybe you've only sold a portion of the business, or you've brought in an investor that has a piece of the business. Finding that right fit is really important. My team can do a great job of navigating you through the legal documents, offering all of the information to the other side to get them comfortable with a deal and getting a deal closed. But what sometimes people forget is it's still a people business. And if you are going to have that ongoing relationship, it's got to be a fit. I really just hate seeing sometimes sellers go for the absolute maximum dollar with people that they hate. And 3 years later, they're calling me asking, okay, how do we get out of this deal? It's not working out. We don't get along. We see a different vision for the business. The business is suffering. There's a lot of things like that. So the money's critically important. We all get that, but paying attention to fit is also important if you get to that point of the process. Also want to point out just kind of the timeline. So say you've now found a buyer that you want to work with. First of all, you're going to negotiate a letter of intent. A letter of intent is usually a fairly short document, 2-3 something pages. It'll have some provisions that make the relationship exclusive for a period of time, say 60, 90 days, really just building a window for the parties to work together and figure out, okay, can we really hammer out a full transaction here? The LOI will list the price. It'll list some of the key terms, the assets or the stock being sold, some of the financial metrics, if there's financing contingencies, just the real nuts and bolts of the deal. So then if you do sign an LOI, you move into what is called the due diligence process. And due diligence, I'll use a housing analogy again. That really kind of looks like your house inspection. So, when you go to buy a house, you want to make sure the roof doesn't leak and the foundation's not broken and all those kinds of, basic things that would be an absolute problem for the buyer after they've bought the house, or in this case, bought the business. So for due diligence, what the buyer will request is that the seller upload all relevant documents, licenses, contracts, things like that to a data room. And from there, the buyer, both internally and with the help of external counsel, such as my team, will go through each and every document. You might think that that's a pretty painstaking process, and honestly it is. But in order to get a real feel for what is being purchased, the buyer wants to know that everything's in order from a number of topics. And you'll see, I don't know how we got question marks on these. These were bullets originally, but looking at each of these topics. So you've got organizational documents, contracts, licenses, real estate, employees, and IP. I left off environmental, unfortunately, but also a critical component in this industry. And there could be others, right? It kind of depends, what the operation of the seller is. And so each of these categories will have a ton of documents. So just kind of stopping for a second, organizational documents. This is basic stuff. Did you form your corporation correctly? Do you have bylaws? Or if you're an LLC, do you have an operating agreement? Have you appropriately issued stock or membership interest? Have you held annual meetings if your organization is required to hold annual meetings? Have you done just the basic things of running a corporation? You'd be surprised how many people don't. Things like having an operating agreement sometimes seem like, oh, well, that's just paperwork. But from a buyer's standpoint, this is really important because if you don't have even the proper corporate organization, if you've gone out and signed contracts, if you've obtained licenses, if you've done things like that, and you don't have a proper organization, some of those things could be found to be invalid? Did you not sign the contracts in the name of your corporation? Sometimes you'll have a founder and he's just out there, signing contracts in his own name with no mention of the company. And that can be a huge problem because the company doesn't have a contract at that point. The founder does. So if the company is looking to assign its contracts or sell its business thinking that that contract has value, well, you kind of have a problem because the contract doesn't exist in the company. There's lots of things that can be done to fix this. I mean, we can always assign the contracts. We can go to the third party and reapply for a license or whatever it might need to be. But it's really important to figure out these things beforehand. I've been in plenty of deals where you start doing due diligence, and a lot of times I've been on buy side, again, representing some of the larger organizations, and you start looking at a smaller business like, man, they didn't do this. They don't have contracts in the right place. We're not sure if their licenses are valid. Their lease is about to expire. They have handshake deals for half of their deals, their suppliers. So as a buyer, the thought process they're going through at that point is, do I really want this? Is this a mess? Is this going to be just an absolute headache that I don't want to deal with? And I'm going to spend the next 2 years fixing everything they should have done right in the first place. And if so, the real risk there is that they just move on to the next company, right? There's lots of targets out there. There's lots of opportunities, or grow it in organically. But it's really a matter of trying to, as a seller, protect yourself from being viewed as a mess or from impacting your valuation, right? Sellers may come into a process and say, look, my company is worth $50 million. We've got all these licenses, we've got all this production. Look at our financials, we're doing great. But the buyer comes in and says, yeah, if you were in good shape, we'd probably give you 50. But given everything that's going to be a problem, and they start adding it up. It's kind of like the checklist again on a housing report. You're going to go buy a house. I want an add back for fixing the roof. I want an add back for fixing the foundation. And they'll go through and do the same thing, right? And they'll say, look, if we buy you, this contract probably goes out the door, so we're going to deduct that amount of revenue. It's going to take us X dollars to fix your license. It's going to take X dollars to fix your environmental problem. And they'll look at it all the way from the actual cost of, fixing something to all the legal costs involved, the accounting costs involved, the risk, right? You start getting into problems where you haven't operated your business correctly. I'm just looking at, for example, the employee bullet point. If you've got, you've treated your employees terribly, from the inception of the business, and they've been underpaid, or you haven't paid them all the time, or there's been harassment as part of the workplace, all of those things come up. The buyer's going to look at all those lawsuits or complaints that have been filed with the state, that have been filed in court, anything like that. And again, there's just more risk there. Okay, we've seen a number of complaints. We think there's a potential for litigation. We know employee A or employee B has filed a complaint. We don't know what's going to happen there. We're going to put a contingency or an escrow to the side that says, maybe the seller gets this money, but only if these things get resolved at a period of time, or we deduct it by the amount that it costs to resolve it. We have to go out and pay settlements of millions of dollars, or we get slapped with fines. I've got a client right now with a lot of government investigations. They're trying to raise upwards of $30 million with an option to sell the company for $300 million sometime in the next year and a half. But right now, their biggest problem was they did not, this is actually a healthcare business, but they did not follow any of the government rules. They were taking Medicare and Medicaid money in a way that was problematic. And they didn't self-report. They didn't fix these things. They didn't have an internal compliance person. And so doing that kind of self-reflection now can save you all sorts of headaches, save you all sorts of money down the road to say, look, we invested the time, the money to do the business, run it the right way, but you'll be rewarded down the road. All right, next slide. And so this is kind of what I was hitting on here. I know we're kind of getting towards our time limit here, so I'm going to wrap it up fairly quickly, but happy to answer any questions. But as I was mentioning a second ago, the biggest issue is find your weaknesses now. As someone who works in this space on the buy side and the sell side, we know what the big weaknesses are, right? There's going to sometimes be a contract here and there that's immaterial that no one's really concerned about. You don't have to clean up every bit, but if you're not filing taxes, if you're not staying in compliance with your licenses, if you're engaging in things that are going to open yourself to large liabilities and lawsuits down the road, these are going to be potential deal breakers. And but if you find them early enough, you can correct them and clean them up at this point. So I will stop there. I know we want to get to some Q&A. Brian, do you want to lead us from there?
Yeah, fantastic. Thank you so much, John, for wrapping today's presentation portion of the program up for us so succinctly. Let's dive right into the Q&A because we want to be respectful of our audience members' times, and I want to definitely dive into some of these fantastic questions that have been posted to the board throughout the hour. So just going chronologically to be respectful of everybody's engagement, we're going to dive right into a question from James Whatmore. I think this question is directed towards you, Paul. And he asked, can you cover the extraction patents that are now being issued, specifically relating to CO2 and ethanol, and how that may affect that segment of the industry specifically? I know you touched on this briefly, but I think I want to dive a little bit deeper.
Sure. Yeah, and I I assume James is referring to Canopy at the end of last year in December was issued a very, very broad CO2 patent and is currently litigating that patent in the Western District of Texas against GW Pharmaceuticals. And so there's a bunch of other kind of very broad patents being issued right now. And this is not uncommon for all other industries, but it generally shakes out this way. Very broad patents get issued first because there's not a lot of written literature out there for the patent office to go find and invalidate the application. Now, in litigation, lawyers go out and we find all sorts of other stuff. We'll unearth a manuscript in German in a library in a university and use that to invalidate the patent. All of these kinds of things get brought up in litigation, and that's where these broad patents usually go to die. That being said, there are some real effects on the industry. I mean, it's technically just about everyone, I think everyone really, who practices CO2 extraction infringes this Canopy patent. There are going to be other patents that are similarly as broad. This goes back, though, to what I mentioned at kind of the very first slide or two, is what really matters is what we do with it. There's a possibility for a few big players to use broad patents and stifle an industry, and that can be very problematic, but we often see a huge backlash when that happens. Think the music industry pre-Napster. There's a backlash that happens. And so I don't know how it's going to shake out. I do know that there are some mechanisms that the industry as a whole can use to fight back against overly broad patents. Cooperation agreements, joint defense agreements, things like that. There are mechanisms within the patent office, at least for now, that can be used to challenge these types of patents and things like that. For now, I think we let Canopy and GW Pharmaceuticals fight it out, and we kind of wait and see what happens. But it's something to be on the lookout for sure.
Yeah, fantastic. Well, thank you for giving us some nuance on that topic specifically. I think that Emily has to hop off here a little bit sooner than our other panelists. I want to dive into a question that she wanted to provide some insight on as well. So we're going to go to the first question posted by Sean Arnold earlier in the conversation. And he asked, if calculations, algorithms, and compilations of data can be protected under copyright, how do you incentivize the industry to share this type of information for purposes of benchmarking specifically?
Yeah, Brian, I honestly, the first part of answering that, I wanted to hear Paul's perspective on the copyright side, because that's like not in my wheelhouse. And then based on your answer, I was going to provide some more information.
That's fair. So from a copyright perspective, it's really important to conceptually understand and distinguish between data that is measured and cannot be copyright protected. So if you just measure data, you are not making any subjective determinations. You're not exercising any creativity. That is not copyright protected, no matter how difficult it was to measure, no matter how much time and effort you spend doing it. Copyright is not an avenue for protection. When you turn that over to another party, or if you are aggregating a bunch of data from other people and start to make subjective determinations about which data to include or exclude, how to interpret that data, when you apply an algorithm to normalize the data, that algorithm has some sort of subjective characteristics into it. Once you do those events, that output, those benchmarks can be copyright protected. So, this is kind of a long-winded way of saying that there's business ways to encourage that type of sharing. My company, Thalo, is working on some avenues to do such a thing. Clearance houses are a mechanism by which companies can maintain their trade secrets, maintain their own intellectual property while turning it over and giving and receiving a benefit of kind of group collections of data and things like that. So, Emily, do you have any additions as to the incentivization on that?
Yeah, I don't, honestly, I was going to take it in a different direction. So perhaps I understood the question differently, but yeah, I don't think as far as incentives, what I was thinking was more along the lines of how to incentivize a business to want to share that benchmarking data, maybe outside of the copyright aspect of it. And in my mind, those thoughts would be the value of the consumer demand side of wanting to know if businesses that they're purchasing products from are sustainable, are environmentally friendly, are good to their communities, these types of things. In my mind, that's an incentive in and of itself, because that's huge. That's your buyers of your products. So perhaps that's a little bit outside of this.
Well, perhaps the answer to this from an IP perspective is really that, IP is intended really to just facilitate those types of incentives, right? It's intended to protect against the dangers that handing it over to someone else might inherently have, right? The fears that manufacturers have, all people in the cannabis industry really have, of turning over their precious information to someone else can be alleviated with the proper intellectual property protections. I think that's kind of what Emily and I were kind of both getting at there.
Yeah.
Fantastic. Well, thank you for providing the sustainability angle to that great question from the audience as well, Emily. I think we're going to dive into two questions that are sort of complementary of one another. I'm going to dive first into the question posed by Stephen Sullivan. Stephen says, I work in energy engineering and sustainability. For energy efficiency design build projects, such as lighting upgrades or water efficiency or ventilation solutions, are there instances of new use patents being sought and or issued for applications in cannabis cultivation or manufacturing? And then, if so, is there a repository for searching these patents to avoid potential claims of patent infringement down the line?
So yeah, great question. The answer to the first question is, absolutely yes. People are definitely seeking out patents in all sorts of aspects to the cannabis industry, cultivation, manufacturing. And the thing to really remember about patents is that most patents, even the most valuable ones, are not a patent on a car. They're a patent on the gasket of a carburetor. They're a patent on a particular component that is a advancement that is part of the whole. So yeah, we're going to see patents come out that are on ventilation solutions and lighting, and which methods for applying certain wavelengths at certain growth stages and things like that. We're absolutely going to start seeing those. Just to keep in mind as well, provisional patents last a year. They never are publicly available. You can never see those. Utility patents have a period of 18 months where they are not published. So potentially you can have a period of a year plus 18 months where no one knows that this application is filed because it's not yet published. Once it does get published by the PTO, if it makes it all that period of time, it is available. It's available on the PTO's website. I don't really prefer that. Google actually has a great patent searching tool specific to the cannabis industry, a repository now for searching these patents to avoid potential claims of infringement. The answer is not yet, but keep your eyes on Thalo's website in the future. That's something we're certainly working on down the road.
Fantastic. I had a feeling that there might be a solution coming down the road specifically. So there's one more question that sort of piggybacks off Stephen's. A second question from Sean Arnold. So thank you again for all the great engagement with today's educational programming. Sean says, adding to Stephen's question, if you've designed a process that you deem trade secret, but later discover someone has patented that same process, what risk do you have in continuing to use the process? And then on top of that, what steps would the patent owner have to take to protect and prevent the use of their particular patent? And is this very commonplace in the cannabis industry as of now?
So complicated question. Yeah. It's not super common, at least to my knowledge. And it's for practical reasons. And I'll kind of explain that here. And so if you think about it, you're using a trade secret. You're not publicly, by definition, you're not publicly using the invention. Okay, so that use of the trade secret is not going to be a bar for someone to get a patent on the same process. However, if that happens, there's something called the prior business use exception in the patent world, where you can, if you get sued later, say, hold on, I've been doing this for 50 years. You can't sue me for doing the same thing. The trademark or the patent owners usually go, okay, fine, we'll just come to an agreement now, because that can blow up their patent or cause all sorts of issues if it turns out it was publicly used. So from a practical perspective, also then the patentee rarely will know if someone else is using a trade secret or patented invention as a trade secret, because it's not publicly available. So for all those practical reasons, it's not super common that it happens. But if you are using a trade secret, it is possible that someone patents it. But you do have an exception if that does happen.
All right. Perfect. Well, I know that we're hitting up on 10 minutes over time, and I did give all the audience members a cue a little bit ago that we were going to only extend by 10 minutes. So I do want to be respectful and aware of all the audience members' times and schedules this afternoon. I feel remiss that Emily had to hop off before we let everybody in our virtual round of applause. So I would take this opportunity to say a huge thank you and appreciation to you, Paul and John, for both leading our program today and really diving deep into your areas of expertise. I know that specifically surrounding some of those copyright, trademarks, and patent particularities that I was not aware of a lot of them. And it was a really enlightening conversation. The edible arrangements thing really just sort of stuck out to me. So I'm definitely going to be keeping an eye on that as it develops. All right. And as always, we're going to close out today's program by highlighting this end of event credit or showcasing this end of event credit sequence, which highlights the 24+ NCIA member businesses that participated and registered to attend today's webinar. Before we let you all go, another huge thank you both to our panel, all of our audience members, and most importantly to NCIA's member business companies, which make our work possible each and every day. If you don't see your business highlighted during this credit sequence, that just means that you need to head to the cannabisindustry.org/join today to join the movement for a responsible and equitable and sustainable cannabis industry. Enjoy, and we'll hopefully see you all again later this month for another NCIA Industry Essentials educational webinar. Until then, have a great one.